Hi, I'm Andy. I'm from Auckland. I'm a lawyer. I'm a blues supporter. That's 3 strikes, but I'm going to push on anyway. I'm going to talk to you today about something relatively esoteric, the Commerce Act, which is specifically a piece of legislation that deals with competition law in New Zealand. I was hoping that John Ballingal was going to set a little bit of context for us, but I think actually the 3 guys who have spoken already have probably done that for me anyway. If I've understood what's going on in your industry correctly, there's a concern that raw materials markets aren't working well for everybody, to put it mildly. There are some legal rules which can be applied within the New Zealand context. I'm not talking about trade issues here, that's sort of more of a macro issue. I'm just talking about the New Zealand context, some rules that might be applied to improve outcomes for you, for your industry, for your employees, for New Zealand more widely, to make sure that you get fair and sustainable outcomes. What I've put up on that slide there is really just by way of a landscape, issues that might be worth you thinking about as you encounter issues on a day-to-day basis in your industry. Most of these will be familiar with you. I know that you all will have worked within the legal environment in your day-to-day business, and I'm going to go through them relatively quickly. Contract is just agreement. If you find that someone you think is perhaps selling logs offshore when they should be selling them to you in breach of an agreement, then your obvious first port of call is to raise that as a possible breach of contract. It's something that you can pursue in the New Zealand courts. If you can demonstrate that you've lost money as a result of that breach of contract, you get damages. It's all pretty straightforward. It's not just about failing to deliver what the logs that you say that you're going to deliver. It's about failing to deliver the right quality of logs, failing to deliver them on time. There's any number of ways in which contracts can be breached. That second word is a word that's mostly only used by lawyers. Torts are a family of legal rules. They're quite diverse. They cover things like negligence and nuisance and defamation. But relevantly for you, there's a species of quite specific torts which could potentially apply in your context. They're called the economic torts, and just at a high level, there's a rule that says you're not allowed to induce someone to breach a contract with someone else. So if I contract with you to supply logs to your facility, and then someone else comes along and offers me a little bit more money, and I say, bug you, I'm going to supply that guy instead, then not only will I be liable to you, but that guy could be liable to you as well. Moving on, that Fair Trading Act, I suspect you've had some exposure to that before. That's really just about prohibiting misleading or deceptive conduct in trade in New Zealand at a high level. So for instance, if I was to say something to you that you then relied upon and then I went back on my word later on, sometimes that will give you a right to get some compensation under the Fair Trading Act. So for instance, if I said to you, we've got a contract for the supply of logs, it's coming up to the end of its term, and I will renew that, and we'll have another 10-year contract after that, and you therefore go ahead and upgrade one of your existing lines facilities. For example, that might be something that will give you a claim against me under the Fair Trading Act. The Overseas Investment Act, I suspect you all know relatively well, following the recent changes to the rules with the ministerial directive letter and then the changes to the Act last year. I just wanted to point out one example that's come up in a different context just over the last couple of weeks. You may be familiar with Agria and the PGG Wrightson instance. So in that case, Alan Lai and the offshore company Agria acquired a stake in PGG Wrightson. They had to get OAO consent in order to do that, and the OAO imposed some conditions on that consent. One of those conditions was that Agria and its directors continue to meet the good character test. There were some breaches of some accounting rules offshore, pretty clear breach of the good character rules, and Agria and Mr. Lai admitted liability for that. They were taken to court by the chief executive of Linds, and as a result ended up paying penalties of more than $100,000 in both instances. Might be a useful way of disciplining people if you think that there has been a breach of a good character test or other conditions that might be attached to a consent going forward. And finally, although I said that I wasn't going to say anything about trade, I would just note again, relatively recently there's been a decision made by Minister Whaafoy in connection with Chinese steel. You probably all heard about the galvanised steel coil matter that went through the High Court last year. I wasn't aware of this. There was another issue concerning a product called hollow steel sections, whatever those are, and the Minister has recently taken a look at that with MBIE's input, concluded that there was only de minimis subsidisation and therefore no action will be taken in that regard. But there are, if you are able to get over the hurdle in connection with the particular act, there is scope for the Minister to impose countervailing or anti-dumping duties, which can make it a little bit tricky for those offshore importers. At a very high level, the Commerce Act really only potentially applies in 4 different ways in your context. I'm going to go through each of those one by one if I don't run out of time. The first head is what I commonly refer to as anti-competitive agreements. If you become aware of an agreement between other parties which you think has the effect of substantially lessening competition in a market in New Zealand, then you may have rights. And one of those rights is to complain to the Commerce Commission, or alternatively you can pursue court action yourself. I've set out a few examples there. I'm not saying that in every case, if you can fit yourself into one of those little arrow points there, you will necessarily have got across the line, but they are things to look out for as you go about your business. That first one, you'll tell me whether or not this is realistic. I'm sort of making these up in a bit of a vacuum. Most markets in New Zealand, I think, are probably still regarded as being regional markets as a result of transport costs. You obviously can't ship logs from one end of the country to the other. And if you become aware of a large forest owner in a particular region who has entered into a contract to sell all of a particular product, I've said unpruned saw logs, could be something else, to a single buyer for a decent period. So it's not 5 minutes. I've said 5 years because that's a relatively reasonable period. If you become aware of that, then there's a question to be asked about whether or not that's going to exclude you from obtaining supply in your part of the market. I'm not sure whether that's a problem for anyone in the room, but if you become aware of it, then it's definitely something worth having a think about. Another instance is where you get a couple of forest owners in a particular market who say, well, we're going to stop supplying that particular guy. That particular mill over there is no longer going to get product from either of us. That's sometimes called a boycott. That's equally problematic. If you become aware of that, again, worth having a look at. The second major prohibition in the Commerce Act is one that you've probably been aware of through press coverage. Comes up from time to time. There have been a few cases in this area just in the last few years. The most recent one concerned real estate, and I acted for one of the real estate companies that got caught up in a Commerce Commission investigation and subsequent High Court proceedings where they alleged that a bunch of people had sat around a table and agreed a price. And if you become aware of that happening, then obviously you're going to squeeze into that first arrow point. 2 forest owners who agree not to supply below whatever that price is, $150, whatever it is, I'm not sure. There are other ways in which you can bring this particular set of provisions to bear. The second category is called restricting output. That's where you get together and say, well, I'm not going to produce more than X units per year. I'm not going to produce more than X units of trees above 20 years or whatever the delineation is. And that third category is called market allocating, and that really arises where you get people who just say, you stick to your patch, I'll stick to my patch, everything will be fine. This is the third major prohibition. As the law stands in New Zealand, very tricky to get across the line on this. There have been a couple of big cases where the Commission has taken a bit of a bath, and it is now relatively reluctant to bring these sorts of cases. These are called Section 36 cases. The concept is that you get someone who has a substantial degree of power in a market, i.e. a monopoly. I always use the example of the old telecom because that was the quintessential example of a company which had a substantial degree of power in a market. And it effectively throws its weight around in that market to the detriment of other players, refuses to deal with people, enters into exclusive contracts, or in some cases engages in what's known as predatory pricing. Those examples that I've given up there are intended to illustrate that for you. Large vertically integrated forest owner refuses to supply a local mill That's obviously a problem for the mill. They won't be able to get logs. That second example is another variation of that same problem where, again, you find that there are people who are just unable to obtain supply as a result of this kind of conduct. And the predatory pricing thing, a bit tricky to apply in this circumstance, but it's got some potential application as well. You may all be familiar with this aspect of the regime. If you are entering into a transaction which is likely to substantially lessen competition in a market, you can go to the Commission and say, here's what I plan to do, are you okay with it? It's called the clearance regime. There's another associated regime called authorization, and it's a common way of getting the Commission to look at a transaction and say, yep, that seems okay. And that happens from time to time. There's probably been 6 or 8 over the last 10 or 15 years in the industry. Going back to the early 2000s, there were some relatively significant transactions, particularly in the CNI, that were flagged for the Commission. So again, if you think about that regional market, whether it's East Coast or Hawke's Bay or wherever it is, if you think about two of the three major forest owners in that region getting together, that's got the potential to lessen competition. It's a bit like putting together, Z and BP, that kind of a transaction. That second example, forest owner acquires one of 2 local mills. That's what we call a vertical merger. It can have similarly anti-competitive effects, again depending on context, but it is again something to keep an eye out for. Or that final example, an overseas buyer acquires a large forest owner really with the intention of then supplying only itself. So that turns into an exclusivity problem as well. There are a number of different things going on outside those 4 core prohibitions in the Commerce Act just at the moment. The first of those is a relatively recent development. Market studies are a tool that's recently been given to the Commission and allows them to investigate a particular market. Would have been interesting to hear what John Ballingal has to say on that. Hi, John. The idea behind the changes to the Commerce Act in this area are to allow the Commission to take a look at a particular market, see what's working well, see what's not working, and then see whether changes need to be made to the rules, to the structure, to other aspects of the way in which business is done in that particular area. The Commission is currently busy doing a fuel study at the moment. Talked about clearances and authorisations. That's a process by which you can get sign-off for a particular transaction. If you're opposed to a particular transaction, there is an opportunity for you to make submissions to the Commission and say, this is not going to be good for us. It's not going to be good for us in the log market, and it's not going to be good for us in the downstream product market. Now, I think that's something that might not have got a lot of airtime just in recent times. But you may take the view that some of your products, I'm sure that there's a wide range of products represented by the people in the room, are actually going to be constrained as a result of the poor log supply, and that might in turn lead to price increases in residential building products. That's going to get attention just given where we are at this point in history. Enforcement, that's really just a comment about how does the Commerce Act come into effect. How do you bring these weapons to bear if that is what you want to do? And the easiest way to do this is to complain to the Commission. If you complain to the Commission and you get their attention and they're willing to take it forward, then they will do the work for you. They'll ask you for some information, and if you help them, then they can use that to take action if you think and if they agree that someone has breached the Commerce Act, one of those prohibitions that we were talking about before. It's got a lot of advantages if you are able to get across that threshold and can convince the Commission to take action, because they do the work for you, they take the risk for you, they tend to be relatively dogged, as you'll have seen from examples in the press, and it'll avoid you being distracted from running your businesses. There is another alternative, which is to take action yourself in the courts if you consider that you've been really badly affected by conduct or a transaction, then you can go ahead and do something yourself. That next point, criminalisation, is really just ratcheting up the stakes in relation to the price fixing prohibition. So price fixing is one of the great evils of competition law. If there is ever evidence of somebody agreeing prices with a competitor, the Commission will nearly always look into it and will nearly always take some form of action. So if you can get evidence of any kind of price fixing or restricting output or market allocating, then that is something that will get their attention. And it will get the attention of the people involved as well, because in the future there will be criminal penalties which attach not just to the companies but potentially to the directors and employees as well. The whole idea is to discourage people from going anywhere close to this sort of stuff. But it's not a lesson that has been well learnt offshore. So it is not impossible that, for instance, you might get two guys sitting around a table in China who agree something that will have the effect of price fixing in New Zealand, and the Commerce Act can have extraterritorial application in that context. It's really hard to explain all of that. If you want to talk about that some more, come and buttonhole me at morning tea. That final point concerns changes to the rules concerning the misuse of market power, which is the Section 36 rule. So I said before that that's of relatively limited application as the law currently stands, thanks to a few unhelpful case decisions by the courts. But there is a law reform project underway which is intended to make it easier. In simple terms, it's moving from a purpose test to an effects test, and providing that conduct which substantially lessens competition in a market will be prohibited as well. So that will be a year or two off, but there will be some scope for that rule to have greater application in industries like yours going forward. The other thing I should say, I've neglected to mention this when I was talking about transactions. One of the things that the Commission is particularly focused on at the moment are transactions which have not been put forward for clearance or authorisation, what they call non-notified transactions. And you might have been aware of a few of these just in recent times. There was one involving the acquisition of some gas pipeline assets in the Bay of Plenty, where First Gas acquired some gas pipelines from Whanganui Gas, I believe. And they didn't go to the Commission. Commission found out about them, took them to court and imposed a penalty on First Gas that was in excess of $3 million. So these are material numbers, and they do act as a real deterrent. In that particular case, the imposition of that fine meant that those assets would not be profitable over their economic lives, 25 years or thereabouts. There's another case going through the courts at the moment which concerns, this will seem quite trivial, two parking buildings in Wellington on Bulcott Street, right across the road from each other. And the transaction was, I think what has really got the Commission interested in that is that they became aware of an earlier transaction, didn't really like it, and then the parties went ahead with a variation of that transaction after that. And the Commission is now taking those parties through the court process. And that court process, as some of you will know, takes years, super expensive, very stressful, really hard on people, and it's a good thing to avoid. So in relation to all of those points, I've directed them more towards what you can do in order to improve the outcomes in domestic log markets, and I've therefore directed it more towards what I understand is going on at the buying end of that market. But you need to bear in mind that it also applies to you as well. So everything that I've said in relation to price fixing between buyers, that applies to you insofar as, you know, if you imagine two mills in a region together, if they got together and said this is the price that we are going to pay for the logs and no more, that sort of thing, you just need to keep an eye on it yourself. I've gone through that really quickly. I know that John mentioned that he's got the Slido set. Maybe I'll wait for questions on that basis going forward, but if anyone wants to stick up their hand and ask me a question now, I'm also happy to do that. Very good. All right, thank you very much.